All right, welcome to This Explainer. Today, we're taking a deep dive into the complete life cycle of labor relations. And I know, labor law might sound like a pretty dense, highly legal topic on the surface, but we are going to transform it into a really fascinating, chronological journey. We're literally tracing the path from that very first initial spark of organizing on the shop floor, all the way to the bargaining table, and sometimes right up to the picket lines. It's this incredible, delicate balance of power, rights, and super strict regulations. So whether you're an employee, a manager, or honestly just someone curious about how the modern workplace actually operates under the law, this map we're about to unfold is absolutely essential to understanding the dynamics of the workforce. Let's get into it.
Okay, let's take a quick look at our map for today. We'll be covering the right to organize, choosing a bargaining representative, rules of union membership, collective bargaining agreements, unfair labor practices, and finally, strikes, lockouts, and disputes.
Starting right at the beginning with Section 1, the right to organize.
So this is the foundational step of the entire labor relations life cycle. In commercial, industrial, agricultural, and yes, even non-profit enterprises, the right to self-organize isn't just some nice suggestion, it is a fundamental constitutional right. It's the cornerstone that lets individuals come together for mutual aid and protection. But to understand who can actually exercise this right, we kind of have to look at the hierarchy of an organization. Right off the bat, rank-and-file employees are fully eligible to form or join unions. Supervisory employees are also eligible, but, and this is a big but, they cannot join the rank-and-file union. They have to form their own separate supervisory unions. On the flip side, you have managerial employees. These are the folks who have the real power to lay down and execute management policies, and they are absolutely prohibited from joining, assisting, or forming any labor organization. Oh, and as a quick side note, while government employees do absolutely have the right to organize for mutual aid, they are strictly prohibited from declaring a strike.
And this brilliantly illustrates the real-world logic of the law, specifically through something called the doctrine of necessary implication. Think about confidential employees for a second. Say, the HR director's executive assistant who types up the company's confidential negotiation strategy. The law actually excludes them from unionizing to prevent divided loyalties and, quite frankly, internal espionage. Now, you might be wondering, what if a union accidentally includes ineligible employees? Like what if a supervisor accidentally gets mixed in with the rank and file? Well, the law is super practical here. This sort of commingling doesn't just cancel or destroy the union's registration. Instead, those ineligible employees are simply and automatically deemed removed from the membership list.
Let's break down the actual types of organizations these eligible workers can form. First, a union exists specifically for the purpose of collective bargaining. Then you have a workers' association, which is geared more toward mutual aid and protection. But keep in mind, an association cannot bargain collectively unless it formally registers as a union later on. Then, zooming out, you have a national union or federation. Think of this as the mother organization, which requires at least 10 legitimate local chapters to form. But here is the massive key takeaway for all of this. None of these groups have any true legal power to represent their members until they achieve legitimate labor organization status. And that only happens upon proper, formal registration with the Department of Labor and Employment, or DOL.
Moving right along to Section 2, choosing a bargaining representative.
So once workers have organized, the very next phase in the life cycle is choosing who will actually speak for them. But how do you decide which workers are grouped together to negotiate in the first place? Well, the Supreme Court uses what's called the substantial mutual interest test. Basically, this means workers are grouped together based on having similar duties, wages, working conditions, and skills. They have to share a true mutuality of interest to form an effective bargaining unit. And once that unit is perfectly defined, the ultimate goal of this whole organizing phase is to designate a SEBA, the sole and exclusive bargaining agent. This is a specific, legitimate labor organization that becomes the singular unified voice for all employees in that unit when sitting across the table from management. Finding this unified voice is absolutely essential for the collective bargaining process to work.
So how does a union actually prove it should be the SEBA? Well, in an unorganized establishment, if a union wants to trigger a statutory certification election, which is an official dole-run election to determine the representative, they need a magic number. They have to gather the written consent of at least 25% of all the employees in that specific bargaining unit. Once you hit that 25% threshold, boom, the election machinery is set in motion.
Now, during this election process, a pretty fascinating legal principle applies called the bystander rule. By law, the employer is considered nothing more than a mere bystander. Think of it like a theater. The workers and their unions are up on the stage figuring out who the lead actor is going to be, and the employer must strictly sit in the audience. They have absolutely no legal standing to oppose, appeal, or participate in the election proceedings. Literally, the only exception is if the employer rightfully questions whether an actual employer-employee relationship even exists in the first place. Otherwise, they just have to sit back and watch.
That brings us to Section 3, Rules of Union Membership. A legitimate labor organization isn't just some casual club. It operates under incredibly strict financial and democratic rules to protect its members. We're talking requirements like majority votes for major policies and holding secret ballot elections for officers every 5 years. But the crucial point here is how these unions are actually funded. The law makes a very specific distinction. A checkoff is the deduction of regular union dues directly from a union member's wages. This strictly requires individual written authorization from that specific worker. But then we have something called the agency fee. Let's say a worker chooses not to join the union, but they're still part of the bargaining unit. They still reap all the benefits of the union's hard negotiations, like better wages and benefits. So, to prevent a free rider scenario, the law allows an agency fee to be deducted from non-members. And importantly, because they are benefiting from the contract, this deduction does not require their individual written authorization.
All right, Section 4, Collective Bargaining Agreements.
Once a CBA is officially chosen, both the union and the employer have a mutual obligation known as the duty to bargain. They are required to meet promptly, expeditiously, and in good faith. But here's the catch. Bargaining in good faith simply means you must honestly try to reach an agreement. The law never forces either party to actually make a concession or agree to a proposal they just don't want to accept. Now, when an agreement is finally reached, it has a very specific mandated lifespan. Let's walk through this timeline, because it's strict. The representation aspect of the CBA, meaning the union's status as the sole bargaining agent, lasts for exactly 5 years. However, all the economic terms, the wages, the benefits, the money stuff, those must be renegotiated no later than 3 years after execution. And then there's this critical window called the freedom period. This happens exactly 60 days immediately preceding the expiration of that 5-year representation status. That 60-day window is literally the only time a rival union can step in and file a petition to challenge the current union for representation rights.
And inside these agreements, the law actually dictates that certain mandatory items must be included. You can't just wing it. You have to include things like a grievance machinery, voluntary arbitration processes, and specific policies for family planning and a drug-free workplace. You'll also typically find union security clauses, which are stipulations that actually compel employees to join the union in order to maintain their employment. But there is a super fascinating exception to this rule. Religious objectors, whose sects expressly prohibit union membership, are completely exempt from forced union membership. This protects their constitutional right to religious freedom. Yet, interestingly enough, they still receive all the standard benefits negotiated in the CBA.
So far, we've basically looked at the orderly, peaceful progression of labor relations. Organizing, voting, negotiating in good faith, signing agreements. It sounds great, but we all know that the real world isn't always so smooth. What happens when negotiations just hit a brick wall? What happens when one side breaks the rules or good faith bargaining completely fails? Well, this is where the labor relations life cycle enters some seriously high-stakes conflict scenarios.
Which leads us to Section 5, Unfair Labor Practices.
It's absolutely crucial to look at this impartially. An unfair labor practice, or a ULP, is not merely a standard breach of contract or a simple workplace disagreement. Under the law, ULPs are considered offenses against the state itself. They are specific acts that directly violate the worker's fundamental constitutional right to self-organize. Let's contrast how the law views violations from both sides of the table, because both can be at fault. On the employer side, a classic ULP is a yellow dog contract. This is where an employer requires a worker to promise not to join a union as a strict condition of getting or keeping their job. Totally illegal. But on the labor organization side, a union can also commit a ULP. For instance, something called feather bedding. This is when a union demands payment from an employer for services or work that was literally never actually performed. The bottom line is, both sides are strictly bound by the law to respect the foundational right to organize and bargain fairly.
And finally, Section 6, Strikes, Lockouts, and Disputes.
When disputes escalate way beyond the boardroom, we start seeing the ultimate leverage tools in labor relations. A strike is a temporary stoppage of work by concerted action of employees. A picket is peacefully marching outside an establishment to publicize a dispute. And a lockout, well, that's the employer's exact counterpart to a strike, a temporary refusal to furnish work. But here's the thing. You cannot just walk off the job on a whim. The law demands a very strict mandatory checklist to execute a valid strike. Step 1, a formal notice of strike must be filed with the National Conciliation and Mediation Board, or NCMB. Step 2, a strike vote actually has to be approved by a majority of the total union members, and it has to be via secret ballot. And Step 3, even after that vote passes, the union must observe a strict 7-day strike ban after reporting the vote to the NCMB.
But what if a strike cripples a hospital, or an airline, or a public utility? In industries that are deemed indispensable to the national interest, the Secretary of the Department of Labor and Employment has the ultimate power to intervene. The Dole Secretary can automatically assume jurisdiction over the dispute, and doing this triggers an instant automatic return to work order. It immediately compels all striking employees to return to their posts, and at the same time, forces the employer to readmit them under the exact same terms that existed before the strike even began, all while the government steps in to forcefully resolve the issue.
So from the very moment an employee decides they want a voice, to the intricate dance of choosing a representative, negotiating a CBA, and sometimes navigating the really high-pressure world of strikes and disputes, labor relations is a meticulously structured ecosystem. It relies entirely on a delicate, carefully legislated balance of power. So looking at these rules, the timelines, and the rights afforded to both workers and management, how does this delicate balance and strict regulation reflect the realities of your own workplace? It's a pretty compelling question to consider as you observe the everyday dynamics at your own job. Thank you so much for joining me on this explainer, and remember to always keep questioning the structures around you.